Right, well, good morning, everybody. As usual, I think the room's filling from the back. For those who don't know me, my name's Matthew Happold. I'm a professor here at the University of Luxembourg, so I've come all the way from the second floor downstairs. But of course, you haven't come to hear me on this first panel on increasing the legitimacy of investor-state dispute settlement, but rather our speaker and commentator. I don't know whether I should yet say discussant or disputant, but we'll see. You've got the biographies, and as I came in, I noticed that the Max Planck Institute has this wonderful thing that they put the biographies up on the screen. So even if you hadn't read the biographies, I'm sure you'd be aware of both our speakers this morning. Jeremy Sharpe, formerly of the State Department, now of Sherman Sterling in London now, and Stephan Schill, for many years the Max Planck Institute Heidelberg, but now with the University of Amsterdam. Now, I've been told that I have to keep rigorously to time, and in order to do that, I will say no more, and I'll hand over to Jeremy. So,
thank you very much, Professor Happold, for the introduction, and I'd like to thank the co-directors for having invited me and the staff for making it possible. As you may have seen from the older program, Yaz Banafatemi was to be here. She sends her regrets. I'll do my best to channel her. I think there's now a fairly familiar criticism of investor-state dispute settlement. Vague and indeterminate obligations are interpreted behind closed doors by private ad hoc tribunals, resulting in inconsistent and unpredictable decisions that drain state coffers, create uncertainty about the scope of a government's authority to regulate, and chill legitimate efforts to promote human rights, the environment, health, safety, and other important public welfare objectives. Not too long ago, I think, this criticism was largely confined to certain NGOs and academics. Today, I think it's part of a much broader political and public consciousness and debate. A prominent United States senator, for instance, has blasted international investment arbitration as pseudo-courts where highly paid corporate lawyers go back and forth between representing corporations one day and sitting in judgment the next. And 100 law professors publicly lambasted international arbitration, investment arbitration, for weakening the rule of law by removing procedural protections of the justice system and using an unaccountable, unreviewable system of adjudication. I think there have been perhaps 4 main responses to this strain of criticism in recent years. The first has been to ignore the narrative entirely, to conclude that the system requires no significant changes. But I think this guard-the-castle approach is increasingly unsustainable, especially in light of the hundreds of thousands of people who have taken this to the street. We heard yesterday that some 11,000 people in this country alone signed petitions against ISDS and TTIP. A second response, perhaps, has been to accept the narrative, wholly or partly, and to call for the elimination of investor-state dispute settlement, to propose something entirely different, perhaps just a return to national court litigation, perhaps diplomatic espousal, state-to-state arbitration. This seems to be the approach, I gather, that many critics prefer. The third has been to accept the narrative, again, wholly or partly, and to propose a different model of investor-state dispute settlement. And I gather that this is what the EU is proposing with this International Investment Court. A fourth response, perhaps, is to recognize that whether or not these criticisms are all legitimate or well-informed or equally serious, they have to be addressed if ISDS is to remain politically viable. This, I have the sense, is what a lot of ISDS practitioners believe. We've seen in recent years many useful efforts to reform the ISDS system. Arguably, many of these already have enhanced its legitimacy. I want to touch on 5 of them, But before I do so, I think it's useful to reflect on the fundamental shift that already has happened in international investment treaty making in recent years. The first generation of international investment agreements lacked mutuality in a key respect. The arguments were promoted by capital exporting states who understood that the burdens would fall disproportionately, if not entirely, on the capital importing states. By contrast, many current international investment agreements, I think including the recent 12-country Trans-Pacific Partnership, are more carefully calibrated to better protect investor and host state interests. The treaty's benefits and burdens are distributed more equally. There are at least three key reasons for this fundamental shift in treaty making. First, experience. More states today have first-hand experience acting as a respondent in investment arbitration. More than 600 disputes have been brought against more than 100 states. States also have more experience negotiating with a broader array of treaty partners. Even countries that have not yet faced an international investment dispute, such as the Netherlands, reportedly have somewhat more balanced international investment treaties with their more economically important treaty partners, such as India or China. The second reason is visibility. Arbitration pleadings and awards are increasingly visible, they're accessible online. States thus have greater insight into how the substantive standards and the procedural rules have been interpreted and applied, not only their own, but other states as well. The third reason is interests. The world, of course, is not as neatly divided into capital importing and capital exporting states. You can see this in the substantial increase in investment flows into developed countries and out from developing countries. UNCTAD recently reported that now a third of global flows of FDI are coming from developing states. It's no surprise then that UNCTAD reported that last year some 40% of investment disputes were brought against developed states. An increasing number of states thus have both foreign investors and their domestic prerogatives to protect. These states want to ensure strong substantive protections for their investors abroad, but also sufficient flexibility to maintain the ability to regulate for the public interest at home. So given this increasing convergence of experience, visibility, and interests, I think states are already better able to agree on appropriate reform of the investor-state dispute settlement system. So let me just mention these 5 areas, broad areas of reform. First, many states are seeking greater control over the development of international investment law itself. Many early BITs were drafted in quite minimalist terms. They didn't give arbitrators or parties much guidance for their interpretation. Many modern international investment agreements, by contrast, define the substantive protections much more clearly and precisely, along with various qualifications or exceptions. For example, recent US international investment agreements, including TPP, specifically identify the factors that are relevant for determining whether regulatory conduct constitutes an indirect expropriation. Similar language can be found in EU agreements. Many newer agreements contain statements such as, except in rare circumstances, non-discriminatory regulatory action by a party that are designed and applied to protect legitimate public welfare objectives, such as public health, safety, and the environment, do not constitute indirect expropriations. Other agreements similarly seek to better define fair and equitable treatment, which is a protection, of course, often criticized for its potential breadth and indeterminacy. The Canada-EU agreement, the CETA, for instance, limits FET to instances where a state measure constitutes denial of justice in a criminal, civil, or administrative proceeding, fundamental breach of due process, manifest arbitrariness, targeted discrimination on manifestly wrongful grounds, or abusive treatment of investors. In this respect, I should note that the United States has taken a different approach. The United States has sought to link fair and equitable treatment to the customary international law minimum standard of treatment. And this will be an interesting test to see how the negotiations for an EU-US agreement come out on this point, because there are different approaches with the EU seeking to better define fair and equitable treatment, and the United States seeking to circumscribe fair and equitable treatment by linking it to a customary international law standard that might not lend itself to this same list of qualifications or definitions that the EU has proposed. From the US perspective, I think the argument has been that because minimum standard of treatment under customary international law is an objective standard that's linked to the state practice, that's the practice of states that they follow from a sense of legal obligation, it should bring greater clarity to the law rather than seeking to define it the way that the EU or some other states have done. We shall see how the negotiations proceed in that respect. A second broad area of reform, states are seeking to promote greater coherence in investor-state dispute settlement. We'll hear about this later, so I'll just say a few words. Many agreements now expressly authorize the non-disputing treaty party to make submissions to a tribunal on questions of treaty interpretation, to clarify the meanings of those obligations. This mechanism should, again in principle, lead to better arbitral decision-making, decisions that are more consistent with the two treaty parties' views of what this standard is intended to mean. I think it's a positive development. You can point to cases like the Mesa versus Canada NAFTA Chapter 11 case, where the Mesa Tribunal invited the non-disputing parties, the United States and Mexico, to weigh in on an arbitral award that the claimant had introduced as an important precedent on a key point in that case. Perhaps we'll see more of that in the future. And of course, many contemporary international investment agreements allow the treaty parties jointly to issue an interpretation about the meaning of the treaty. We saw this recently with with China and Laos, providing an interpretation on the territorial scope of the China-Laos BIT, which led a court in Singapore to then set aside the award in the Sanam versus Laos case. A third broad area of reform, states have been narrowing the types of permissible claims and claimants. Some states are simply eliminating procedures or substantive protections that they deem problematic. Critics of ISDS have often pointed to similar or identical provisions that have been interpreted differently. One example that has been given is the umbrella clause, which has been interpreted differently. Interestingly, UNCTAD reported that, as far as they know, not one BIT concluded last year contained an umbrella clause. The United States eliminated the umbrella clause from its model investment treaties in 1994. But again, the reason is interesting as we think about reform of the system. The United States did it in the context of the negotiations of the Energy Charter Treaty. And at least one US negotiator reported that the United States became concerned about the potential breadth of a requirement to observe all obligations with respect to investments. And the concern was obligations, other treaty obligations, customary international obligations. So the United States eliminated the umbrella clause. But it's interesting, at the same time that the United States eliminated the umbrella clause from its model, it was reporting in letters from the President to the Senate that the customary international law of investment protection still prevented states from repudiating contracts. So it's interesting. One wonders how much of an effect the deletion of the umbrella clause was expected to have in US agreements. Now the United States seems to have taken a more middle-of-the-road approach. If you've looked at the TPP, it protects against breaches of investment agreements, which are specifically defined terms, a written agreement between an investor and an investment and a central level of government authority with respect to certain identified sectors like natural resources. So it's not an umbrella clause as such, it's arguably provides some lesser level of protection. It's a sombrero clause or something that's smaller than umbrella. So another key complaint about investment arbitration is that the a large number of international investment agreements, including bilateral investment agreements, has allowed for forum shopping. To guard against this, of course, many international investment agreements today have a denial of benefits clause that prevent the investor from seeking to obtain the benefits if they lack substantial business activities in the home state, or where the investor is owned by a person from a state in which the host lacks diplomatic relations. And this helps prevent treaty shopping and through the creation of mailbox companies or sham companies, and also seeks to protect important foreign policy interests of the state. A fourth broad area of reform, states have been seeking to exercise better control over the development of the arbitration process. Many recent international investment agreements specify much more precisely what kinds of claims can be brought and how they may be prosecuted. This is, of course, a big change from earlier bits. The US 1982 model bit, for instance, contained a single article on investor-state dispute settlement, and now if you look at the 2012 model, it contains 13 articles covering 12 pages of the treaty. There are detailed provisions on elements of consent to arbitration, consolidation of claims, steps to promote efficiency and transparency, including requiring the publication of arbitration documents, opening the hearings to the public, amicus submissions, and so forth. Significantly, and as Colin Brown mentioned yesterday, many current international investment agreements authorize tribunals to dispose of non-meritorious claims by preliminary decision and to award attorney's fees in those cases. Contemporary agreements also increasingly contain provisions on arbitrator qualifications, conduct, and selection. CETA, for instance, is a good example in this regard. On arbitrator qualifications, the agreement provides arbitrators appointed pursuant to this section shall have experience or expertise in public international law, in particular international investment law. It is desirable that they have experience or expertise in international trade law and the resolution of disputes arising under international investment or international trade agreements. On arbitrator conduct, CETA similarly contains provisions seeking to ensure arbitrator independence and impartiality, including by requiring compliance with the IBA guidelines on conflicts of interest, and I gather the Singapore Agreement goes even further with a code of conduct, which is also called for in the new TPP. On arbitrator selection, CETA calls for the establishment of a roster of at least 15 qualified persons to serve as presiding arbitrator when the parties cannot agree. I was remarking to Colin, this is perhaps easier said than done. The NAFTA similarly calls for a roster of 45 arbitrators, but the United States, Canada, and Mexico have never been able to agree, although I gather the EU is having more success than we've had in North America. As a final reform, states are taking steps to ensure the authority and discretion to regulate for legitimate public welfare objectives. I won't go through all these, but non-conforming measures, essential security clauses, things of that sort. So to my mind, I think these 5 broad areas of reform go a long way in addressing criticisms of investor-state dispute settlement. I think the current system's bilateralism, though, has been an essential strength of the system. Because there are so many bilateral investment treaties, each state has been able to decide for itself and with its treaty partners the substantive protections and the procedural reforms that it thinks are appropriate, and to strike that balance itself with its treaty partners. The system, as a result, is not static. It's very dynamic. It's evolving. I think it would have been much more difficult if we already had a global investment treaty and perhaps an international investment court to have the same kind of dynamism and evolution of the law that we're currently seeing. The question now is whether politically ISDS can continue to exist and evolve, or whether something else entirely will be required, such as international investment court. I find it interesting that the court proposal is coming just at the moment when many states are reaching a consensus on the kinds of reforms that they think are appropriate for ISDS and are implementing those reforms in the newest generation of international investment agreements. I can't speak for the US government, of course, but I was trying to put on my US government hat listening to the discussion yesterday at the roundtable, thinking about how the United States Department of State and the trade representative might respond to a proposal for an international investment court. Madame Reding spoke of one world, one law, one court. She thought that it would be better for the United States and Europe to write the rules of trade for the 21st century rather than, say, China. In this respect, I think she'll find a welcome reception. President Obama said on the conclusion of the TPP, we can't let countries like China write the rules for the global economy. We should write those rules, opening new markets to American products while setting high standards for protecting workers and preserving our environment. I'm less sure how the United States might react to the concept of one law. Again, the current system's bilateralism has allowed states to participate more actively in the development of this area of the law, but I'm not sure that we have consensus entirely yet, such that we could have one law for the rule. And so what about, finally, one court? Madame Reding argued forcefully that what ISDS lacks is clear, binding jurisprudence. But is the United States or other states ready for an international court to pronounce definitively on the content of those rules of international law? Or might each state prefer, together with its treaty partners, to continue developing the law before arbitrations through better treaty drafting, during arbitrations through pleadings and non-disputing party submissions, and after arbitrations, perhaps through joint interpretations and renegotiation or new treaties? I'll leave it to Stephan to answer those questions. Thank you.
Jerry, thank you very much. And thank you for keeping to time. Stephan, over to you then.
Yeah, thanks a lot first for the invitation. It's a pleasure to be here again. Jeremy, I think, provided a good overview of why we see recalibration at present and what is being recalibrated. And essentially, the state is assuming an increasingly important role in the whole endeavor. At the same time, he also noted that while there's broad agreement about the problems we face in ISDS and the fact that we need to reform, there's not sufficient agreement about the content and forms of reform on both sides of the Atlantic. And I think if we look at the reformed ISDS system that has now come into TPP and compare that to the EU proposal on TTIP, the differences could perhaps not be starker. So I think there's a risk of fragmentation in the reform debate. And that risk of fragmentation does not only exist on both sides of the Atlantic, but I think it's a global phenomenon. There's a large number of reform proposals coming from international organizations such as UNCTAD and the OECD, regional organizations such as SADC, the EU or ASEAN, by various states through reformed model BITs such as India and the US, by NGOs and experts initiatives like IISD in Canada or E15, and of course, not to forget, by academics. And I'm guilty as charged as well. So all of this risks to create confusion and fragmentation in the reform debate in an area that should be predictable. That's what investment law wants to achieve. This fragmentation, I think, is unlikely to actually increase the legitimacy of the field, but it perhaps indicates that we have different ideas of what legitimacy means on both sides of the Atlantic and among different constituencies. And I think the same question can also be addressed, so do we actually have a consented idea of legitimacy if we look at the recalibration process? Because interestingly, on the one side, there's a fear that states may now encroach too much in reforming the system, while on the other side, there's the perception that states are still not sufficiently re-regulating and recalibrating. So and then the question is also on what normative grounds do we bring these contrary political, social and economic views together about state-market relations, and how do we create consensus to start a reform process that is consented not within countries' constituencies, but more broadly, more globally. So I think if we try to develop a normative framework for reform, then it's key to go back and understand the current criticism, the core of the legitimacy crisis. I think there's much noise in this respect, but in my view, the poodle's core is really that investor-state dispute settlement constitutes a system of public governance, because state conduct is reviewed according to international standard, and because arbitral tribunals also incrementally develop the law and become lawmakers. So while there's an exercise of public authority here, the whole system does not conform to the standards that constitutional law in liberal democracies usually demands of similar activities at the domestic level in respect of adjudication and jurisprudential lawmaking. And I think there are a number of factors in ISDS that can be understood as challenges to constitutional ideas. There's, of course, the fact that this is a system for foreigners only, so there's a problem perhaps with equality. There's a problem of inconsistencies in the system, so that may go against the idea of the rule of law and predictability. There's a lack of transparency in the past, and perhaps problems with accountability of arbitrators because their democratic legitimacy is not as high as that of domestic judges. And of course, if we consider that some rebalancing of private and public could take place through these processes, we have a problem for democracy and human rights. And I think this is exactly the normative grounds on which much of the criticism is currently formulated. I think Ms. Weber yesterday illustrated that quite well. It's an issue of democracy for her, it's an issue of human rights, and it's perhaps an issue of the rule of law. So all of these are constitutional values that are brought as arguments against the system. And I think in order to respond to them properly, we need to provide responses that are based on constitutional law. We have to provide responses that can then, I hope, not only respond to the criticism in the language in which it is brought, but perhaps constitutional law is also a basis on which to develop a more broader normative framework on which to develop an idea of legitimacy. So this could be both balancing with respect to the different interests involved, but perhaps also a more broadly consented normative basis. Now, of course, this cannot be the idea of constitutional law in Europe or in the US or in Luxembourg or in the Central African Republic, but we need to take, I think, a comparative approach. We need to find an internationally mitigated global constitutional basis for reforming investment law. One area, I think, is comparative constitutional law that could help us to understand better what democracy, human rights, and the rule of law mean for structuring, for devising international dispute settlement mechanisms for investor-state relations. But we could also look at international constitutional principles, principles that come from UN law, and one article, I think, that could be informative in the whole enterprise is Article 55 of the UN Charter, that speaks of the need for stability, the need for peaceful settlement of disputes, for international cooperation, for equality, for human rights, self-determination, and social progress. So this could be a shared normative basis, and the question then is, how does that translate into concrete reform proposals for ISDS? And I think there, the first point is, of course, that a comparative constitutional exercise suggests that there should be an opportunity for recourse to a neutral forum for affected individuals, affected investors, and to have government acts reviewed. If that is true, then we could provide access to justice at the domestic level, or if there are problems at the international level. And I think problems at the domestic level exist even in developed countries if we look at length of proceedings, home state bias, the non-application of international law in domestic courts, sometimes access restrictions for foreigners, or review restrictions by domestic courts if we think of the US political questions doctrine. So even in developed countries, with respect to certain aspects, there is a claim to be made that we need recourse to an international forum. If that's true, then endeavors to disengage from the current regime by exiting the Exit Convention, by exiting BITs are, at least to a certain extent, questionable. So comparative constitutional law provides a justification to have recourse to an international forum. At the same time, of course, one needs to think more about the relationships that international recourse should have to domestic courts. The principle of democracy, again understood in a comparative basis, I think supports certain reform efforts, such as ensuring policy space, ensuring a certain democratic control of international dispute settlement mechanisms through joint committees, for instance. But it also supports thinking about how do we better legitimize decision makers in ISDS. How should the appointment process look like? This could mitigate for closed lists, but it certainly mitigates for transparency. The rule of law. Now, that would require and militate for increasing predictability in the area, for concretizing substantive standards, and again also to introduce perhaps control mechanisms through appeals systems. But I think it also mitigates to consider better how we deal with the problem of cross-BIT inconsistencies. And I think here multilateral approaches are really the only answers to deal with this problem. The rule of law then finally also mitigates to ensure access of SMEs to the system. And the EU proposal does here goes a big step in that direction. But I think it would also suggest that we should think about support mechanisms for weak states in the system, such as we see in the WTO with the advisory center. So I think rule of law, access to justice are arguments that can help in reforming the current system without bringing it down. Now, all in all, I think that comparative public law thinking could help to constitute and to develop a shared normative basis for investment law reform and provide balanced solutions by getting inspiration from more experienced dispute settlement systems in how they deal with settling investor-state disputes. Now, to close, just a few comments on the current TTIP tribunal proposal by the EU. I think it's an ambitious proposal, and I think it breathes the right spirit because it is really inspired by public law thinking with rules on transparency, third-party participation, code of ethics, more predictability, and ensuring policy space. I think there are two main shortcomings that I see. One is the bilateral setup of the reform proposals. Now, it will be difficult to tackle cross-regime inconsistencies with bilateral tribunals that pop up everywhere. Do we really want to have dozens of bilateral permanent tribunals instead of the ad hoc investor-state dispute settlement system? Can that really be the answer, or don't we need a proposal that can multilateralize itself more easily? The second shortcoming is that I think we need to think more about how to better integrate domestic courts into dispute settlement in ISDS. Now, my proposal would be that a TTIP tribunal should be construed from the start so that it can be multilateralized easily by third countries joining the statute. and to provide or develop a system that's attractive also for third parties, I think we cannot start with judges that are appointed by the two contracting parties, but we need judges that are appointed through multilateral processes so as to allow third parties to join the tribunal. After all, in investor-state arbitration and perhaps also in the TTIP tribunal, the neutral arbitrators, the neutral judges would be decisive anyways. And finally, how can we integrate domestic courts better into the system? And perhaps what we could imagine here is that at the first instance, an investor-state dispute could be settled by a single-tier domestic instance, which could be somewhere at the appeals level, or also giving states the opportunity to devise international dispute settlement mechanisms at the domestic level, such as we're seeing currently in Dubai or in Singapore, and then provide for an international recourse appeal system at the second level. With that, I come to an end, and I'm looking forward to the discussion.
Thank you, Stephan. Well, we started late, as is always the case. But I think we still are permitted 10 minutes or so to take questions from the floor. So I will throw it open. If anyone does have anything they want to say. There's a roving mic, I think.
Thank you, Laurence Boisson-Chazon. It's a question to Jeremy and Stephan about the need to link this, the investment arbitration to local realities and to ground or to link it to constitutional values. And I think that is something we will discuss later on. And Stephan alluded to the need for an international comparative constitutional law branch. The question that I have is that how different that would be from public international law as such, when we have all these instruments dealing with human rights, environment, and health safety, and so on.
Stephan, I think that's probably primarily addressed to you, so you could go first.
I mean, as a public international lawyer, I would, of course, say that perhaps there's not that much of a need for it, but I think that a comparative constitutional approach would help to bridge the divide that still exists between international law and domestic law, and the perceptions that are out there among domestic constituencies that whatever is happening at the international level is so different from the domestic level and so disconnected from the domestic level that we need some sort of bridge. And I think that showing to which extent domestic systems are comparable, are similar, perhaps have similar ideas and solutions for the same problems, we could show that what should be happening at the international level and what I think is currently already happening in the past in investor-state arbitration is really not different from what would happen at the domestic level. So I think it's a way to bring investor-state dispute settlement somewhat closer to domestic law.
Jeremy, do you want to come in on the comparative constitutional law?
I think it is interesting that constitutional principles are being adopted into international investment agreements. If you look at the three-part test from the Penn Central case in the U.S. Supreme Court about the degree of the expropriatory measure, the character, and whether there were reasonable investment-backed expectations, you see that test replicated in other treaties not involving the United States. At the same time, you see some interest among arbitrators in using a global constitutional or regulatory analysis in their decision-making. I think the difficulty that states might have is they would prefer to do this analysis and to make these calibrations upfront and put it in the treaty rather than allowing tribunals, giving tribunals the authority to make too broad of an interpretation and looking at too many different sources. Otherwise, what are we creating with investor-state dispute settlement tribunals? Is it really a super court, like a Supreme Court, that looks at the full range of law and that is before it? Or is it more narrowly defined as deciding a dispute between an investor and a state on certain defined causes of action based on public international law, of course, but how much do we expect arbitrators to become comparativists and to look at these issues at the global level from whether constitutional or administrative law perspective? I'm just not sure that states are comfortable setting up that process. And to the extent they're valuable to incorporate these principles, I think the states will want to bring them into the treaties. That's not to discount the role that arbitral tribunals have. When an arbitral tribunal makes a determination and has done some of this analysis, states, of course, respond in their pleadings, in non-disputing party submissions, and possibly even incorporating those decisions into their treaties, positively or negatively, accepting that determination and having it reflected in the treaty, or negatively rejecting that interpretation and ensuring that subsequent interpretations do not follow that line. So there's an iterative process between states and arbitral tribunals. I'm just concerned from the state perspective about whether they want to create the kind of courts that engage in analysis that Stephan has, the kind of tribunals that engage in analysis that Stephan has identified.
I don't know if Stephan wants to come back on that. Okay, any other questions? All right, go on. The mic is somewhere. It's over there.
Thank you, Blurina Gerai from the University of Geneva. It's a question for Professor Schill. The reason why ISDS was introduced, first of all, was to bring the process far from domestic courts and to denationalize. Now, the proposal that you made to bring back the process to domestic courts, what would be your suggestion or proposal? What guarantees can we have in this second attempt to bring the process back to domestic courts that things will change at the domestic level? Thank you.
Questions for you.
I would not envision bringing the process entirely back to the domestic level. So the idea would more that the domestic level could take a first shot at resolving the dispute, both under domestic law and ideally under international law as well. And then that there's a second tier that is entirely international that would review the first instance level, and that would particularly review whether states complied with their international obligations. Now, the difference to the old system of exhausting local remedies is that you would only have one tier at the domestic level, and that tier would be not sort of a first instance court, but a court of appeals or perhaps even the Supreme Court of that country. So you have much better skilled judges, ideally perhaps with an international outlook, and they would need to have, of course, only a certain time to make their decisions. It's perhaps a way to bring something back to the domestic level and also give the criticism an ear that the domestic level is completely shut out in the current system. Again, that's an idea. I think we should sort of think more about creative ways of integrating domestic and international law, just as we did in the European Union. And I think the relationship between domestic courts in EU member states and the ECJ through the referral procedure, for instance, has been something that has made EU law so successful. And I would hope that perhaps something similar could be done with other areas of international law. Here, international investment law.
Jeremy, do you have a rejoinder to that?
No, I think I'll...
Okay, right. I think, do we have time for one more question? One, please.
Yes.
Whoever's got the mic, I suppose.
Now, we need a settlement. My question might sound a little bit amateurish, as I'm not from the legal world. If I'm an investor and I have a dispute, and if now in this new mode of ISDS, there is an approachment of, there's a narrowing gap with national tribunals. What will, in the end, be my advantage of going ISDS or local national tribunals? Is there still a significant advantage for the one or for the other in very practical terms?
Well, I think one of the great advantages of international arbitration, whether it's commercial arbitration or investment arbitration, is simply a perceived neutral forum, and foreigners generally tend to prefer not to be in the domestic courts. It's not necessarily that they have distrust of domestic courts in a foreign country so much as it's not a neutral, perceived neutral forum. So I think I'm not sure that we would see any decrease in international arbitration when parties are able to choose between domestic courts or international arbitration, simply because of the desire everywhere for parties to avoid subjecting their rights and obligations to domestic law in domestic courts that is not their own.
So I fear we have to end there because we have another panel. So please join me. Jeremy, Stephan, thank you very much. Please join with me in thanking them in the usual way.